Yeah, want specific results, but at least to see the idea that we might bring an application later, so we'll still be waiting for that. No, Professor, very interesting presentation, and you bring to us so much knowledge. If I would have such presentation in front of our course, I would have titled it, How to Grow Oranges in Romania or in Germany, because we don't have too much leniency, so you see, I mean, there is heat outside, but no oranges still in Romanian soil. And the different, let's say, culture, the different climate for Romania. COT is a young market economy, young competition agency. We come from a past which is centralized and police controlled state, in which informants were blamed. Informants is already because you know it from Eastern Germany, for instance, in but it was even worse, let's say, in some parts of Europe. So then we have this young enforcement, we have this very country, of course, should dissipate because time is goes on and we should adapt what is efficient. Leniency is efficient, companies should use it, but still we are still we're not complaining too much. So we are working to detect ourselves as cartels, and we can do it. You see, the Great Commission, we gave this example on the other side of Europe, huge success out of leniency, like 3/4 of the cartel cases all are based on leniency applications, or at least a second degree leniency in these cases. But even the Commission officials at some point they started to be worried. Oh, there's too many already. Our skills will start to disappear if we continue this way. Our staff will not longer be able to detect ex officio, so on its own, such behavior. It was just waiting for someone to knock at the door. And a lot of people knock at the door. Besides, there will be the applicants setting the Commission's agenda, because we want to prioritize with all these industries, but someone knocked at the door, look, there's a cartel. In the other part, look at this cartel. So we have to take into account. The Commission is not, you see, this is too much success on leniency. It was not good. And now, this they announce that they try to shake the trust from their weaponry and to go back again in the markets to look themselves what's happening. So we're not, so it's different situations. We are in this part of Europe still trying to, or waiting to get more of these applications. For example, we had applications, but it would be harder to find leniency. So we said, okay, let's be serious on what to do, so don't just, okay, some good information. I said, I tell you the climate. I think it's another reason that was everywhere, why leniency is not always beyond the legal arguments and even ethical arguments. It can be everywhere with ethical arguments. Why go and say something bad? Are you sure the cartel? Go back. Are you sure? I go and ask the cartel, but I'm sure the cartel. And that's at this point it's even so very Romanian, because companies, they need to realize what's happening. So they have to, okay, we talk to some competitors. Do we know if it's a cartel or just legitimate cooperation among the companies which exist in markets? So companies should not fight all the time. So it's a very thin line and they have to be aware. Even if they discover that, okay, guys, we realize that what we were doing was really bad. The managers will have a tough choice. It could be very responsible for themselves. The company shares, the company's managers, some person with power to denounce wrongdoing. So if you look at them, it works better if you have a compliance program and shareholders are notified. The company, through the managers, did this. Otherwise, the managers themselves will be, their dilemma will be even hard. Not just business dilemma, like individual. Because at some point, the shareholders will try to see who's the wrongdoings. So it's not a lot of obstacles on the road to leniency. But as I tend to agree with you that leniency should not be exaggerated. So it is useful, but not in every case. I think this was also your point. One point which I wouldn't agree not everybody is the issue of individual responsibility, even criminal responsibility. But in general, as a way, the manager is in dilemma. If he also faces a clear direct liability, like from a public authority, not from the shareholders, he might be more incentivized if he gets forgiveness also for his guilt. He may have a better incentive to come and say, we did this and I was involved, so that he will not be sanctioned. So it works to have because sanction is the stick that the companies need to have. And companies and individuals also should both have, and why I say criminal liability, because criminal liability is in principle applicable to individuals in these companies. And we have such a provision in the Romanian competition law that participate in coordinating just the people who are the leaders in a cartel can be sanctioned with prison of up to 3 years. So that's in the United States, but it will increase to 5 soon. So it's an amendment which is proposed. They care it's not by sending messages to the market. We work with the office. We work in this moment, we work in the future. So basically, we try to penetrate the market from every place we can get information back to us. But we work in the criminal prosecutor's office because we know that it will increase this pressure on companies and on the individuals taking decisions in these companies. Because they can be also very responsible. We know that, you mentioned, there is a criminal leniency procedure, and it's not so difficult to coordinate. Of course, it's like in leniency in various jurisdictions, so you need coordination. So what we did is that we got in touch with the office and we established a protocol, methods, improving them day by day, methods of if someone comes to us for leniency, and we know that at least we have solutions, the approach of leniency, but people are concerned on but what we do, we can be responsible on the criminal. The criminal section was not too much applied, but we like it. So they knew it, but also we want to push it. Also guys, the same day, come to us, we go to the office, you apply for leniency in both places, and our procedures go basically in parallel. So we also cooperate on what goes for criminal liability with them. It's not so difficult, but quite, I think, quite appropriate in the context. That is for the context. So the Commission Council increased its enforcement activity. We could expect more leniency, not so much, but it could be a sign that our enforcement was not really at the right level. And we see, by the way, this is the only point in which we really care about leniency, because it's said, it's a kind of pledge of the competition world, that having a lot of these applications means you are effective and feared competition authority in your area of competence. So, if I take it in this, I don't think it's really true, but of course we are taken by this flow, by this fashion in the competition, public competition enforcement, and we like to have leniency, but not letting our weapons, our methods of detection unused. So we want to keep them and to have leniency just like a supplement coming in addition.
commentary or complementary statement, since I'm preparing an article on that matter. By the way, the other author will be a representative of a developing state outside Europe. So that's exactly the problem I'm interested in, what you were commenting on the different political climate. And I agree, of course, there are, especially on the criminal law thing, there might be a very different view whether this is good and what extent would be good. At least very developed states like the United States, they said, due to their culture, of course, to much higher degree of criminal sanction as we do in Europe. However, I nevertheless speak on my position concerning that I would prefer more private enforcement instead of too much state authority thing. Besides the fact that Variety was a very wise link to the East German tradition, but nevertheless I would even claim for West German. Let's say since 1871, the Prussian influence on Germany, which made it rather believing in state powers and such things, administrative tools are the better.
Do not stop, and we cannot stop the flow of private enforcement. It's the natural human against the right people, natural right things, if you want. So private enforcement should be there. Public enforcement at some point is questionable how much, how far. So I mean,
yes, thank you. I think indeed both tools should be used, public and private enforcement, while depending on the culture, it could be very debatable how much criminal law sanctions apply directly. Even in our law against unfair competition, which was stressed to a high degree in Germany, which is one of the core fields of private enforcement, not of cartels, but of market behavior in general, since 1896. And even in such a field, you find some criminal sanctions, but used as additional tools, and even in regular, in the practice of regular companies of management, we have at least some criminal sanctions related to bankruptcy law and insider information and other behavior. Indeed, so it can be a useful tool, of course, without doubt. My argumentation was just where to go in the mainstream and how to relate, especially the public enforcement tools, the tools of authority, which is, you are correct, I think, especially necessary in respect of the very nature of cartel prosecution and cartel enforcement, which is always directed to be preventive, to go to the future. That's exactly a thing private enforcement could not guarantee anymore. That's a thing somebody has to do, which is able to do the market analysis and to say, okay, well, what are the risks and how do we deal with the risks? That's indeed a matter of state authority. While the other way of, let's say, getting this undesired behavior, getting grasp of that undesired behavior, there are, of course, different ways, different tools. Think about it before. Well, that's another point. Yeah, okay, so far I will go comment.
Of course, the most interesting topic for us as, let's say, very beginners or close to beginners in this competition enforcement area. May I remind you, and of course, reveal to Professor Obermann that our National Competition Council what would you say to those who might argue that with private enforcement you would have all the means, all the legal means on one hand, and of course the information, otherwise there will be no revealing, no whistleblowing, if you would have certain very important relevant information. And therefore this leniency would work as a tool in the hands of a very manipulative undertaking in order to take its competitors out of the market.
I think that's one possible constellation, of course, which resembles one. I mean, very closely. If you take this air cargo cases, it's of course close to behavior where the whistleblowers try to get to bring disadvantages to the other market runners. I think it's indeed one risk of leniency programs. But one precondition, of course, tries to clarify the situation, and nobody who created this cartel, coerced others to go into the cartel, is eligible to get to advantage of immunity, and that takes away already part of the cases. It's one of the adverse effects possible, of course, that undertaking manipulating using the measures very well is able, of course, to get advantages by such legal behavior. But by the way, this happens generally in private prosecution, of course, that if you take this, the private law measures to ask other parties, other firms to interfere with specific market behavior, for example, in unfair competition law, this of course constitutes a kind of second market of legal tools where people fight against each other with the help of their attorney. That's indeed the case. Sometimes it makes sense for them, say for specific markets, to bring hundreds of different behavior and many small lawsuits, like placing bombs on a specific tower in order that others, newcomers, cannot move anymore. So that could be a risk of private interference in that respect, of course. But so far, I think in our, some people didn't like it at all, but in our experiences with private enforcement in competition matters, and this was highly developed with, at least in Germany, with high incentives set by not by the lawgiver, but not by the parliament, but by the courts, by jurisdiction. For example, based on the fact that the other side, if there was a letter just to inform the other party, written by an attorney, that they did something wrong in competition. What we have mentioned before, the parties don't know even sometimes that they built a cartel, or that some behavior was maybe against trademark law or whatever, what they did. And if you inform the party according to the rules existing in what Germany, at least for almost 50 years, the other party has to pay this move, this pre-court move, by paying the cost of the attorney for that information, because it wasn't information on their behalf. 30 years later, the law, the enactment was following and giving a positive rule of that kind, so clarifying this matter. So this is one of the incentives I was talking about, how you could challenge and let's say increase private engagement, but also, of course, you need, especially in using such leniency programs, be careful that they are not misused, I think. So this is a real danger mention. Of course, in some critiques in legal literature, they take this under the headline "the adverse effects of leniency programs." I think this is an exemption, nevertheless, because you still have the authority. another word I'd like to say, if I may, as another point for the question, how strict should we be as cartel enforcement? I mean, because you mentioned before the history of more authoritative approach of the political system. And I mean, the basic decision is that you don't have a market in that sense, as we had in the socialist experiments in Eastern Europe. In that case, you don't have a cartel problem in that sense, because you don't believe in the market. But as soon as you state there will be a market, and the market is, in our belief, I mean, if you state so, I'm not sure whether I'm convinced of it, the best distributor in the sense of allocation efficiency to bring the goods and services to in cheapest cost in the best way to the other side who needs them. If this is done by the market, the whole thing is a kind of game. And what cartel law in substantial sense tries to do is to ensure that this game is working, that this game is going on. So, and I think the role of the state is then to ensure this kind of game of state authorities. But I think if we bring that too much to a very strict control of market behavior, it could be adverse and create such adverse effects. So that's, by the way, the inner reason why I'm just for limited sanctions in that sense, in that respect, because it deals with the behavior of people on markets. It might be criminal in some cases, but we shouldn't criminalize it too easily.
Well, in Romania there is yet no risk of overflow formation, this is for sure, in order to apply the literacy. For certain, the Competition Council won't be flooded with information. To be perfectly honest, I've sensed that even in the recent past, the undertakings are rather reluctant to provide information, even the required one. And there are still sanctions applied for concealing information. This is something that you won't believe in 2013. However, it's still true and still applicable. But again, this reluctance might come from the risks that are attached to the problem and to the system of people to it. And of course, until much success would be done at the EU level, the Romanians would be still reluctant to follow, and will have no prisoner dilemma. We'll know upfront that there is no dilemma, just keep your mouth shut and you'll be fine, hopefully. Or not.
Why it doesn't work in Romania? Yes, program companies see the life in terms of profits and losses. This is normal. Mostly companies can foresee the possible losses from fines, competition council, investigation of an official. They don't see the benefits yet of the agency. It's not a clear image. Okay, it can be sanctioned, and companies are more and more aware. We notice this in the surveys that we make every year. We make surveys of companies, public authorities, and consumers. And this competition culture awareness increases, but still it's not very clear. Okay, what we can get out of this? This will be much clearer when cases of the council based on leniency will be enough. You can only tell at the end of the investigation, or can be seen from the number in. You can see a company which was sanctioned or was found to be infringed the law, but has a zero fine, and you can guess that it was a leniency applicant, even if it's not specified. So when these cases, we are working on such cases, when they will be finalized, and it will have much clear signal that coming to the authority pays for it. So it can be a business because, as it's very remarkable what you made before, companies can be used to commute have to come with leniency. It's a council's duty to detect more behaviors. It's first incentive that you, clients, companies come to and denounce themselves, or to announce the success stories, because it should be like a success story. A company chose involved in a hardcore infringement, but still got no fine. Looks wonderful. Today's world, such an offer hardly can be refused. Only when you see people that again, are not rushing, focusing on the certification of cartels. You mentioned very stable. Any young authority or should be so. It's even difficult to start with a lot of leniency. It could be like false signals, but intoxication, you can receive a lot of false signals even that way. Even from the companies, not knowing what they did. And then it comes to one point, just how much time do we have? Whistleblowing is a general coordination when the company, the undertaking itself comes and puts the facts on the table. But the whistleblower, so these informants in companies, and for instance, we can tell that we give serious consideration to such good information. You see, the company has the kind of a lot of internal bureaucracy before you come to it. You have to analyze it, realize that you are in infringement, and analyze to see, the manager has to see if, how much you will suffer out of this. Sometimes we go to law firm, to shareholders, whatever. But you can always have someone that wants to talk anything about it. I think we have such information, so we receive information from informants. We cannot reward them, it's not provided already. Hunger, and I think also it's extending this kind of thing. But how is sound from say legal point of view, and how is sound to allow ethical, again, of this blood performance in the community side, individual physical person doing that. So you see, my to be pragmatic, and if information comes and it's good information, just accept it.
Yes, just the letter. I think very much it's already a great final statement, I would say. But just to the letter point, I mean, if you take whistleblowing in a broader sense, it opens many other legal problems, no doubt about it. There has been, I think it's 1.5 years ago, this decision of the European Court of Human Rights concerning an individual whistleblower who lost his job because of whistleblowing, and they strengthened the rights of the whistleblower in order to promote such information about wrongdoing of the management from the inside of the bureaucracy to get outside. So I think it was a correct decision to do so. So there was no anyone want to go against whistleblower as a general phenomenon or even embrace it in that sense. Just use the term for the cartel leniency broker in the lower sense. In that other, broader sense, I would 100% agree with you, because that's a thing to promote, and it makes a lot of sense to give that information not only to authority, maybe to other market members too.
We accept information wherever we need now. It's a good information, then it's good information. Don't care too much. But is it ethical? Is ethical? We like to be efficient, so it's a delicate balance. Not from any sort, of course, not in any situation. Look at the person. And then, of course, we try to avoid this intoxication. People can have something against the company, so it can be used as an instrument. So.
Sure, it can be.
Of course, the discussion may be broadened as much as possible. This can only be the starting point for a larger discussion on leniency and on whistleblowing in general, and in particular in competition law. We have reached the end of our interesting